Ready? Exercise number 19 and 20 legal matter. Start. This appeal impugns the order dated 24/4/2018 dismissing the appellant's claim for compensation under Section 166 of the Motor Vehicles Act 1988. He had claimed a compensation of rupees 20 lakh for the injuries suffered by the claimant on account of an accident of the insured motorcycle, whereon he was riding pillion on 29/12/2014 in a thick fog near village Sauda and Naya Gaon Bypass Road, Haryana. A motor car being driven in a rash and negligent manner suddenly came from the opposite direction without blowing any horn, and the glare of its headlight blinded the motorcyclists, causing disbalancing of their motorcycle, resulting in both falling down and sustaining injuries. The appellant, along with the motorcyclist, were rushed to a hospital in Bahadurgarh district, Jhajjar, Haryana. The claim is against the driver of the offending motor vehicle for driving it in a rash and negligent manner. However, this argument is untenable because it is quite implausible for anybody to be blinded by the glare of the headlights of a car in a thick fog. Besides, all prudent motor vehicles drivers or motorcyclists would ordinarily drive at a speed lesser than usual in a thick fog. Indeed, the thicker the fog, the lesser the speed. The court would note that the appellant, who sat on the motorcycle of his friend or acquaintance, is a gratuitous passenger. Apart from merely stating that the offending vehicle was being driven in a rash and negligent manner, no other allegation has been made, nor has any evidence been laid in this regard. As already stated, it is implausible for somebody to be blinded in a thick fog by sharp light. On the contrary, what is shown from the record is that there was a speed breaker which perhaps the motorcyclist did not spot, and because of which the riders fell down and sustained the injuries. The impugned order has dealt with the issue as under. I have perused the complaint given by petitioner to the police, exhibit PW1/5. In the said complaint, it is stated by the petitioner that on 29/12/2014 he was going on a motorcycle bearing number DLS 7762 as a pillion rider from village Gangarwa, district Jhajjar, Haryana to village Nilothi at about 8 p.m. to 8:30 p.m. when they reached near village Naya Gaon Bypass Road, Haryana. He was one car coming from front side at a high speed, which was being driven by its driver in a rash and negligent manner and in zigzag manner. Stop. Next exercise. The plaintiff filed a suit on 18th November 1964 for a declaration his proprietary rights in about 1720 acres of forest land, both measured and unmeasured. The learned single judge substantially decreed the suit. The learned single judge held that the plaintiff's father, who in internal matters had sovereign powers had bestowed the lands in dispute as a perpetual and unconditional grant on the plaintiff. The mere fact that in the mutation entry the areas was shown to be 263.4 bighas did not imply that the grant was limited to that much land only. In the state of Bushhar, only cultivated land was generally measured and forest lands remained unmeasured, and therefore the area of only revenue yielding cultivated land was mentioned in the mutation entry. The evidence considered as a whole fully established that the grant was not repudiated but was given effect to by the political agent Shimla as well as by the revenue authorities of Bushhar state and was also recognized by the Dominion of India at the time of the state's merger. Even assuming that the lands in dispute formed part of forests leased to the government of Punjab, the Raja was not precluded from making the great grant, and the grants made in favor of the plaintiff were perfectly legal and valid. After the lease was terminated on 11th April 1949, the Himachal Pradesh administration treated the plaintiff as the owner and permitted him various acts as owner and person in possession. Notifications were issued under Section 4 of the Himachal Pradesh Act 1954 declaring the disputed land as private forest, and the notification issued under Section 29 of the Indian Forest Act 1927 had no application to such lands. The division bench allowing the state appeal inter alia took the view that after the execution of the lease deed dated 25th September 1942 in favor of the government of Punjab, the Raja had no surviving or subsisting right in the forest lands in question which he could transfer by way of a grant. At the most, the grant made by the erstwhile ruler could take effect in respect of revenue yielding lands only, at measuring about 263.5 bighas and not in respect of the forest lands, and that the notification under Section 29 of the Indian Forest Act was validly issued, and so long as it held the field, no notification could be issued under Section 4 of the Himachal Pradesh Private Forest Act 1954. Full stop. Thank you.